The topic given to me is the Constitution of India and social justice. And let's see what justice one can do to this particular thematic. And I think Vineet gave a very nice introduction to the current relevance or importance of the Constitution. I think the phrase he used is that the Constitution has become notably prevalent in public life today, and it's an actor in some ways which it wasn't any time in the past. And what is that due to? And that's the question I want to begin by addressing. In fact, I mean the way I thought I'll go about it is this: firstly, address in a sense this entire question of why is the constitution relevant at all. That's the first question I want to address. Then I want to go on to looking into the question of if you're saying constitution and social justice, in what way does the Indian constitution enact a social revolution in terms of its normative architecture and framework, not necessarily in terms of what it actually finally does, but in terms of the normative architecture and the framework that it sets in place. Then I want to address, I think, the question which all of you are very interested in, the entire question of the limitations of the Constitution as well, and try and map out in some ways or what can be a way forward in future which is foreshadowed by a certain kind of what you call an undeclared emergency or what you call a certain kind of fascism. What is the way forward, keeping this wonderful document called the Constitution with us? Maybe not waving it like Rajiv Gandhi, but Rahul Gandhi, but still keeping it as a kind of a backdrop, as a kind of as a frame or a way of thinking, understanding its limitations as well. So that's the way I thought I'll proceed. And begin with the first question, which I think is the most important question of why look at the Constitution at all? After all, end of the day, it's a piece of paper, it's a document. And what is the importance of a document which is a legal document end of the day, right? And I want to address that by making the point that we go back to trying to understand the Constitution not just in terms of, as a legal document alone, which is what as lawyers we tend to do, but seeing the document in a sense as a product of a social or a political struggle, and seeing the document an outcome of that kind of a process itself. And I think maybe three references over here. You go to Mr. Kanabaran's work and go to this really, I'm sure most of you have read it, his brilliant collection of articles called The Wages of Impunity. And he makes the point that Constitution framed after a liberation struggle or as a struggle for independence is like poetry, emotion recollected in tranquility. It's a severance from the past, termination of imposed suzerainty, and the setting up of a political sovereignty of one's own people. And this line of thinking of the Constitution as a product of struggle is also mirrored by the other, I think, really brilliant human rights thinker, who I think all of you know again, Mr. Balgopal, where he makes the point that, again, a very important point, on the whole, without some struggle or agitation, rights do not accrue. A right takes shape in some people's minds, in their thoughts, then it spreads into the social consciousness. It gets recognized finally in the political practice. So, again, the idea that rights and struggle are linked. And the third reference point is actually Professor Bakshi, Upendra Bakshi, again, who makes the point rights are a product, what he calls people in resistance and communities in struggle. So, the simple point I'm making is we need to understand fundamentally the Constitution and the rights that we have is really a product of a struggle and underlying struggle. What the struggle is, we'll get to in a bit, but we understand that it's a product of a struggle. And maybe one more reference point, which I'm tempted to also make, is you go back to again, I think Comrade Tiago was very interested in this point, and I'm sure he'll correct me on this point. Go back to Capital Volume 1 and Marx's Capital Volume 1, the chapter on the working day. And if you read that chapter closely, what he maps out is how do the legal limits to the working day arise? And you get a sense that the limits to the working day really arose out of a range of factory inspectors' reports, range of protests and demonstrations, range of ways in which this idea that the working day should be limited emerged. And again, there's a very, very beautiful phrase where he says that in place of the pompous catalogue of the inalienable rights of man comes the modest Magna Carta of legally limited working day, which at last makes clear when the time which the worker sells is ended and when his own begins. So the idea that again, that when you talk about rights, fundamentally, it's really a product of struggle. And we can't look at it outside that. And so in a sense, I think even prior to political parties taking up on the question of the constitution, the issue of the constitution was taken up in people's struggles around the country. And we saw it particularly during the anti-CAA protests, and we've seen in a range of struggles before that itself. So the idea of a defense of the ideas underlying the constitution is not something we owe to political parties or the current political parties. It really comes from the people's movement, and political parties have come to it late. But they've come to it late. That they've taken to it a lot later than people's movements took to it. So in a sense, I mean, the Balgopal point, right, about how rights in a sense are born out of people's movement and they emerge from people's movement of consciousness and finally attain a certain kind of political recognition. That's maybe the process of transition or the shift which we're seeing in terms of understanding the constitution as really worthy of this kind of the document which encodes and recognizes the range of rights which people have struggled and really people have really fought for. And perhaps the other point I want to make, okay, is fine, we take this point, right? We take this point that the constitution is a product of struggle. What is the struggle that the constitution is a product of then? That's the second question we really have to address. And I'll make 2 points over here. One, obviously, this is quite an obvious point. We all know. I mean, if you read the preamble, if you read the fundamental duties, you get a sense, right? That the fundamental duties will make the point that the Constitution, your duty is to have a reverence to the Constitution because it's a product of the national movement. The idea that the Constitution is a product of the national movement, which means that the idea of equality, of all citizens, the idea that racial categories don't matter, that equality is a principle which you encode, is really an outcome of this kind of a national movement, a national struggle. That's one part. And that's the struggle against external domination. And that's, I think, a very, very central part of the dimension of the Indian Constitution. But I think the equally important dimension which we have to understand is the Constitution is also a product of a struggle against internal domination. And that's a very significant and very, very important point for us to keep in mind. And the internal domination includes clearly two very significant dimensions. One is the struggle against the institution called caste, and second is struggle against the institution called patriarchy. And both those struggles find their place in the language or in the way the constitutional structure really evolves. And we'll try and I'll try and look at my second point, which is the second big point, which is if you're saying the Indian Constitution enacts a form of social revolution in terms of norms, right? What are those norms which the Indian Constitution puts in place for us to understand those norms before we get into critique of it, right? And here I'd make a couple of points. A couple of points in terms of the norms that we want to talk about is perhaps maybe one background point I want to make. I'll just make it now. Is when we look at the Constitution and what it stands for, the document we often go to is the preamble. Why do we go to the preamble as a document which encodes the ideals of the Constitution? One way of phrasing it, of course, Professor Bakshi's understanding, where it says the Constitution is really a footnote to the preamble. So that really sets out the vision. And the Constitution tries to implement, to a greater or lesser extent, the vision which is encoded in the preamble. And one background document there is, just for our own understanding, is something called the Objectives Resolution, which Nehru moves in 1946 itself. And the Objectives Resolution becomes the base of what finally becomes the preamble. And perhaps just one point to note over here, the Objectives Resolution, by and large, the preamble mirrors the Objectives Resolution. But there are two significant gaps, and the two significant gaps again point out to the way the Constitution evolves as a document or a product of struggle. The Objectives Resolution does not mention the concept of dignity, and the Objectives Resolution does not mention the concept of fraternity. And those two concepts enter the Indian Constitution because of the advocacy of Ambedkar And that's the point which Akash Singh Rathore makes in his book called Ambedkar's Preamble. So again, just a background point on what enters the preamble to the advocacy of Ambedkar. That being said, the other point I want to make actually is very, very interesting, right? When the Nehru moves the objective resolution, which by and large talks about freedom of speech, expression, association, talks about the concept of equality, talks about the concept of the concept of freedom in freedom and justice in a broader sense. The Everybody responds to the objective resolution, narrowing the objective resolution with really overwhelming speeches saying such a broadly, I'm paraphrasing, broadly saying that, we support the movement we support you moving the resolution. We agree with the terminology of the resolution, etc., etc. One person who disagrees is Ambedkar. And I'll just read out to you what he has to say. Again, it's very interesting if you look at it from today's viewpoint. He says, when one reads that part of the resolution reminds one of the Declaration of the Rights of Man, which was pronounced by the French Constituent Assembly. I think I'm right in suggesting that after the lapse of practically 450 years, the Declaration of the Rights of Man and the principles which are embodied in it has become part and parcel of our mental makeup. I say they become not only the part and parcel of the mental makeup of modern man in every civilized part of the world, but also in our own country, which is so orthodox, so archaic in its thought and its social structure, hardly anyone can be found to deny its validity. To repeat it now as a resolution does is to say the least pure pedantry. These principles have become the silent, immaculate premise of our outlook, therefore unnecessary to proclaim as forming a part of our creed. What is interesting, again, I read it a little quickly, but what is interesting about this is you read it, Ambedkar's critique of Nehru's moving the resolution is that it does not go far enough. It's not that he doesn't agree with what it lays out. He says that that's part, in his language, what he says is the resolution that you moved is a part and parcel of the mental makeup of modern man in every civilized part of the world. He also in our own country. So he says, what's the big deal? You're not saying anything new. We all agree with this. Right? We all agree with this. And as we go through the principles, you'll realize that actually today, right, that time people agree, everybody agreed with it. Then Ambedkar's only difference is not that I don't agree with the principles, it's that you're not going far enough. You claim to be a socialist, and all you're doing is putting in place these range of principles which are so banal. But today, I think those principles have a very different kind of meaning, and that's what we'll look at a little more closely now. So, what are these principles one is talking about, right? And they want to address broadly these five ideas very quickly, which is, of course, the concept of equality, the concept of dignity, the the concept of fraternity, the idea of liberty, or the idea of liberty of freedom, and finally, to the what connects all of them is the concept of constitutional morality, right? And we'll look a little bit at these five concepts. Equality, again, I think by now, there's the importance of equality. I'll just make one point about the principle, the importance of equality. Of course, it's new. As far as those who say that there's a continuity between the colonial constitution and the Indian constitution, the one important point to note is the principle of equality. There is Article 14, Article 15, and the idea that non-discrimination on the sex, gender, race, caste is new. It didn't exist in the colonial order. Right? And that's a very, very important point. Because again, look at the principle of equality. What is it a counterpoint to? It's really a counterpoint to going back to the Manusmriti. And the idea of the Manusmriti, you read it closely as a legal document. The idea of the Manusmriti is the exact counter of the concept of equality, in the sense that who you are determines the punishment that you get under the Manusmriti. If you're an upper caste man, or if you're a lower caste man, the punishment is vastly different in terms of what the legal regime prescribes. So in that sense, the idea of equality is an important development. Again, here the interesting reference point again is going back to the draft penal code, which out of which the Indian penal code was finally came in. Ambedkar has a response to the draft penal code, and he says he welcomes the idea that it's based on the equality of all persons. It doesn't matter in criminal law under the British. It didn't matter in terms of the normative framework. It didn't matter what caste you came from. If you committed a murder, you committed a murder and you were charged under that particular law. Under the Manusmriti, of course, if you committed a murder, it depended on who's the murderer and who's the murderer. That's what the penalty really depended upon. So the idea of equality in that sense is a very, very important innovation which we should not really forget. The second point I want to make is the introduction of the concept of dignity. Again, the idea again go back to the preamble, which is the point I made earlier, is objective resolution did not have the word dignity. The preamble has the concept of dignity. Where does preamble? Where does the concept of dignity figure in the preamble? It says assuring the dignity of the individual and the unity and integrity of the nation. That's the language which is there in the preamble. At that moment in time, the proposal from the House was to alter it, saying assuring the unity of the nation and the dignity of the individual. And the House finally went with the idea that we should put the dignity of the individual before the idea of unity of the nation. And the understanding was this, that there is, when you say dignity of the individual precedes the unity of the nation, what you're centering is a philosophical centering of the individual of the nation. It's not just a lexical priority, it's also a philosophical priority. You're saying that unless you protect the dignity of the individual, you can't really protect the unity of the nation. So there's again an interesting way in which legal argumentation can be made in terms of making this point. Or why is it that the preamble emphasizes the dignity of the individual or the unity of the nation, going back to the Constituent Assembly debates, etc. That's one point. The second point I want to make on the question of dignity is again, why was Ambedkar keen on articulating the notion of dignity? And of course, we can trace it back to waiting for a visa and his own experience of humiliation and the concept that, humiliation is the experience of caste in this country. And in a sense, you have to find a counter to that. The counter to that is, of course, normative counter to that, of course, is the idea of equality. And the normative counter to that, of course, is the idea of dignity. And why dignity again? I'll read out to you what he has to say. If I may say so, the servile classes do not care for social amelioration. The want and poverty, which has been their lot, is nothing to them as compared to the insult and indignity which they have to bear as a result of the vicious social order. Not bread, but honor is what they want. So it's a very powerful articulation of what dignity means. Dignity is really the other of humiliation. Humiliation is the law or is the experience of the Dalit community in the Indian context. So the idea of dignity comes as a counter to that. But again, the other important point I want to make, again, this is a point again going back to the question of law, is the idea that once a concept is there, the concept in its universal sense can apply to groups not originally envisaged by the founding fathers or founding mothers, as the case may be. And that's what we've seen over a period of time. I think if you look at the jurisprudence of the Supreme Court in terms of the idea of dignity, they link the notion of dignity to the notion of prisoners' rights in terms of the question of access to literature and the access to books and access to family visits, etc. They link the notion of dignity to the freedom from solitary confinement. They link the notion of dignity again to the question of sexual orientation and gender identity and the idea that that people have the right to make choices about the personal or intimate life. And that again is a part of your dignity. That again is a part of the counter to the politics of to the concept of humiliation. So again, it's I think, a very, very important concept, which we have to flesh out and take forward. Sometimes with the courts, sometimes outside the court, sometimes as the CAA protest showed in the public sphere. CAA protest only showed that the language of preamble is being used. How do you go content? How do you breathe life into these concepts? How do you breathe life into the concept of dignity and take it forward? And that's, I think, in a sense, really the role of people's movements or people's struggles in giving meaning to the languages of the Indian Constitution. The third concept I want to reference is the idea of fraternity. And again, you go back to the preamble, go back to the objective resolution, go back to the draft constitution. The draft constitution did not have the word fraternity. Fraternity comes in again because Ambedkar insists that it be there. And again, why did Ambedkar insist on fraternity being there in the preamble to the Indian Constitution? I'll read out to you what he says. He says fraternity means a sense of common brotherhood of all Indians. It is the principle which gives unity and solidarity to social life. It is a difficult thing to achieve. This is because in India there are castes, and the castes are anti-national in the first place because they bring about separation of social life. So the idea that that you have to, if you don't transcend this question of caste, if you don't struggle with the question of caste, then what does this freedom that you're entering into is the question that he's raising. And fraternity is a normative principle, and dignity is a normative principle, equality is a normative principle, which gives you a handle or a way of challenging this entire question called caste in the normative framework itself. And one more point he makes on fraternity, which I think is very important. He talks about, again, we talked about three: liberty, equality, and fraternity. And fraternity is the least understood, least theorized part of the entire framework. And even till today, we don't talk much about fraternity because it comes across as maybe kind of slightly abstract compared to, say, liberty or equality. And the way he frames it, he says liberty without equality will lead to the dominance of the few. Equality without liberty will kill individual initiative. And liberty and equality without fraternity will be no deeper than a coat of paint. Right? So, in a sense, right, this challenging question of how do you look at the relationship with liberty and equality in Ambedkar's understanding is mediated through the notion called fraternity. Again, see, the point being, I mean, these are not, to me, these are not abstract concepts. Of course, they're abstract concepts, but our job is how do you make these abstract concepts real, right? How do you find a way to get this meaning? How do you find a way in your legal argumentation, the social movement struggle, to get in fraternity as a way of advocating on a range of issues? We use this in the PUCL. We use the concept of fraternity in terms of advocacy, in terms of the Dakshin Kannada context, where there were all these attacks, right, on boys and girls in romantic relationships. Boys and girls want to have a coffee or a tea together from different religious communities. And these ways of really what we said, that these are really attacks on the fundamental principle of fraternity, apart from the principle of autonomy. It's a question of you're attacking the social order, which we want to create, which we want to build, which challenges this idea that we live in discrete and separate communities. So I think it's really up to us to see how we can take forward, right, these principles which are there in the Constitution. Of course, one more point on fraternity, which has been mentioned in the Ambedkar context, is the annihilation of caste and the advocacy there of the entire question of intercaste marriages, where he uses the phrase when blood begins to mix with blood. That's when you can think of the entire question of the end of the system called caste. So there's a way in which, I think getting back to these principles, going deeper into them, seeing what the meaning is, and seeing what they mean in our own particular context is a very important, very precious endeavor. And the last concept, which I want to reference from the from the Constitution, is the concept of constitutional morality. Again, if you go back to the Constitutional Assembly debates, you'll find out that the only reference point to the language of constitutional morality comes again from Ambedkar's work. Right? He's the one who references the idea of constitutional morality. And the way he puts it again is really, I think, really, really powerful. The way he puts it, he says that constitutional morality is not a natural sentiment. It has to be cultivated. We must realize that our people have yet to learn it. And he goes on to say, democracy in India is a top dressing on a soil which is essentially undemocratic. Again, it's a very important concept because what he's saying, what he's advocating, articulating, is the idea that, we can have all the rights that we want. But if we don't change the way our society is, then all of this will essentially be a top dressing. That's so the idea that the social revolution is significant and important is Ambedkar's articulation when he's talking about the question of constitutional morality. Again, I think it's a very powerful phrase when he goes back to Ranade and his essay on Ranade and Jinnah. Again, I'm paraphrasing, but he's talking about a political prisoner, and he phrases it this way: he says, "End of the day, a political prisoner has behind him the support of the entire community." This talking about colonial times, of course. But a political radical, you want to put it that way, but a social radical or somebody who's challenging norms of society is always alone. Right? So there's a way in which how do you build this idea of constitutional morality? Because our people yet to learn democracy. That's the point he's making. It's here, of course, both caste and gender are highly significant in terms of how they constrain or restrain, our ways, our imaginations and ways of function. And again, here, maybe I'll just quote a little bit from, I think, again, a very important judgment of the Supreme Court, which is the Pudduswamy judgment on privacy, which understands a little bit of this dimension of constitutional morality. Right? Uh, and I think a very important point. I'll just read out to you a little bit of what the court says. The purpose of elevating certain rights to the state of guaranteed fundamental rights is to insulate the exercise from the disdain of majorities, whether legislative or popular. The guarantee of constitutional rights does not depend upon the exercise being favorably regarded by majoritarian opinion. The test of popular acceptance does not furnish a valid basis to disregard rights which are conferred with the sanctity of constitutional protection. Discrete and insular minorities face grave dangers of discrimination for the simple reason that the views, beliefs, or way of life does not accord with the mainstream. Yet in a democracy, yet in a democratic constitution founded on the rule of law, the rights are as sacred as those conferred on other citizens to protect their freedoms and liberties. Of course, the court uses this concept that that when you say fundamental rights, you mean they're not subject to the disdain of majorities, and the majorities can be legislative or popular, but a majority cannot tamper with your fundamental rights. Again, going back to the language of the Constitution, rights are something which are not conferred. So the court does not confer rights, it only confirms them. Right? So the idea that these are rights which you hold because by virtue of being human, right? And they can't be taken away, from you merely because the majority says that you don't have these rights. So this leads again to a very, very important concept, which is we have to understand that India is not a majoritarian democracy, but a constitutional democracy. And the idea that the question of the majority is subject to the discipline of the constitution. Again, this is the normative framework, the normative architecture, which I'm trying to put forward. Then there's one last, sorry, I should have said one last point which I want to make, which I think is actually very, very important in terms of the normative framework of the architecture, which we think, which underlies the Indian Constitution. I've referred a lot to the question of dignity, equality, and the concept I didn't refer to, which is very important, is the idea of liberty, right? And liberty, what do you mean by liberty? And again, going back to Mr. Kanavaran's work, he used language, which is very, very interesting, is that in the wages of impunity, that you think of the relationship between three series of rights: the question of speech, the question of association, and the question of assembly. And that is fundamentally what lies at the base of our ability to protect the rights that we have. And when we refer to people's movements go back to these three fundamental concepts. You must have the right to speech, you must have the right to association, and you must have the right to assembly. And these, of course, are rights which are under significant threat or challenge in the India of today. Both in terms of going back to constitutional history, going back to the drafting of Article 19 and the range of reasonable restrictions in 19, to the current mode, when you had laws such as what we call ordinarily the draconian laws, which is the Unlawful Activities Prevention Act, and of course the current BNS, right? All of which significantly tamper or significantly limit your ability to exercise the right to speech, association, and assembly. And maybe just a little bit going back a little bit to these three rights and why they're so critical, so crucial. Again, see, when we look at the Indian Constitution, this is actually very, very, very fundamental, because the idea, if you go back to again Ambedkar's language, right? How do you bring about peaceful change within the framework of the Constitution? The only way you can do it is if we are guaranteed the right to speech, the right to association, and the right to assembly. And we know that these are three rights are the most fundamental threat in the country, right? In the country as of now. And here, perhaps, I'll just reference one very important point, which I think is worth, which we have to know, which I'm sure all of you know, is the is the new legal regime under which we live, which is the three new criminal laws. And the PUCL came out with a recent study, a recent report, which we called turning a de facto police regime to a de jure police state, critical of the three new criminal laws. Right? What might have been a de facto police regime after the three criminal laws have come into place is today de jure police state. And that's the very troubling and very dangerous position we find ourselves in. And perhaps just a quick reference point on this is in terms of the BNS, right? The Bharatiya, the language again, I dare not say it in this forum. You also find it difficult to pronounce the word. And I'm sure you'll agree with me that it's not easy to say. We'll leave it as BNS. We don't know what the N stands for. But the BNS, uh, 152, Section 152, right, introduces the law of sedition in a new avatar, right, in a more dangerous avatar. So I think, again, it's so dangerous where the government uses the language of anti-colonial language, saying that they're getting for an anti-colonial law, they're actually reinforcing the deepest kind of a colonial prejudices. And here, 152 of the sedition law. The previous sedition law was an exciting disaffection against the government established by law. Here, I think the language which I didn't read out to you is what is also criminalized under this is encouraging feelings. Mark the word, encouraging feelings of separatist activities or endanger sovereignty, unity, and integrity of India. Right? And this feelings of separatist activities we're not seen in any statute till now. How do you criminalize anybody encouraging feelings of separatist activities? In this presentation, if we have a section, if I'm going to say self-determination, right, is not a right within the Indian Constitution. Is that going to be encouraging the feelings of separatist activities, right? So you get a sense of how broad-ranging this particular provision is. And here again, going back to in history, when you say this colonial, go back to again Gandhiji's trial under the then sedition law, where he called the then one section sedition law as the prince among the political provisions of the Indian Penal Code designed to suppress the liberty of the individual. Right. So there's a way in which this idea of freedom of speech is central to democratic order. And the idea of freedom of speech is what is being challenged most fundamentally by this new kind of BNS. And the second thing, of course, is that the BNS includes the question of terrorist offense. It's the same language as the UAPA within the ordinary criminal law. So you transition from the UAPA, so-called an extraordinary law, to the BNS, which is the ordinary everyday criminal law. And the other technical point, I'll just make this point, I don't want to go too much into it, is to think, right? I mean, when Gandhiji referred to the sedition law as a prince among the political provisions of the Indian Penal Code, what he's referring to is the division of the IPC. The IPC has this idea of offense against the body, offense against property, offense against state. And under offense against state, sedition was one of the offenses, right? But here, terrorist offenses comes an offense against the human body. It's intriguing. Why do you get terrorist offenses against the human body? Surely, I mean, whatever the BNS drafters thought, surely they didn't think that is an offense against the human body. In their own thinking, it should be a very serious offense against the state. Why is it an offense against the human body? And the logic of it is this, right? It's a technical procedural point, which is the idea that if it's an offense against the state, the sanction of the state is necessary before cognizance of the offense can be taken by the court. But offense against the body, you don't need sanction of the state. So they seem to have gone by using just this technical route to try and bypass even the issue of sanction. If you go back again, the question of Arundhati Roy, right? What the LG did recently is give sanction to prosecute Arundhati Roy. So sanction is the basis before you can file, the court takes cognizance for an offense under the UAPA, and that is a requirement is being bypassed in this new inclusion of this terrorist offense under the BNS. So the last point to make really on this, of course, there's a lot, and I'm not going to go into the range of changes which the BNS and the BNNS bring in. because that's another discussion and all in full. And there's a paper which I'm very happy to share, done by the PUCL, looking at these three laws and looking at the shift from a de facto police regime to de jure uh, police state. And again, what you see in this is this increasing power of the state, and the state is becoming more and more unaccountable. And if that's not colonial, I don't know what you describe as colonial. Where the idea that the constitution does not matter. If anything, right? If you're saying the constitution does not matter, these laws are what put the put the signature or put the seal on the fact that the constitution does not matter. You make once these laws come into force or once they're implemented, then the constitution does not matter, because where's the freedom of speech, where's the right to association, where's the right to assembly, because all of this comes within the frame of the criminal law. So unless there's a ways in which these provisions are struck down, it's going to be very, very difficult for us to take forward the rights which you've taken forward till now under this new legal regime. One more point I want to make really about this entire question of these laws is uh, the going back maybe to the point of one one thing which people's movements can contribute and have contributed, I think, in a very significant way uh, to this discourse on human rights is actually something which Roosevelt put forward. He put forward this idea of the four freedoms: the freedom from fear, the freedom from want, the freedom from religious persecution, and the fourth freedom escapes free for now. But the freedom from fear, right, is an important freedom. And again, the idea: when do you have a freedom from fear? It's a very important question. And I think here that again is very, very closely linked to the speech, association, and assembly question. The only way you can cultivate a freedom from fear is through being a part of assemblies, being a part of associations, because courage, I think, in many senses, is a very collective phenomenon. So I think to break the sense of fear again, these three rights become very significant and very important. So this is a very important normative architecture which I want to reference, which is the idea that we must think of the idea of equality, dignity, fraternity, constitutional morality, and liberty as significant interlocking principles, which are really about what the Constitution signifies or means, and the heart of what we mean when we say when we wave the preamble or wave images of the Constitution around. This is what fundamentally we want to protect. And the reason these are important is again not because they're mere words in paper, but because these words have been given life to by people struggle. Again, it's a very important point. I just may make this point actually when uh, Krishna delivered the Shankar Guha Niyogi Memorial Lecture. Uh, he referred to Shankar Guha Niyogi and said that Shankar Guha Niyogi breathed life into the constitution for the millions of workers and Adivasis in the uh, throughout the country. Right. So the idea that who breathes life into the constitution are really people's movements, and that's really the point. The point I want to stress. I want to make again and again. That being said, maybe the last point I want to address now, the third part of what I wanted to address is the entire question of what are the limitations? What are the limitations of the of the of the Indian Constitution? Right? We've talked so much about what the strengths might be. What are the limitations? What can't it do? Right? And I think you'll be honest and upfront and admit what the Constitution can't do and the Constitution is not doing. Right? And we have to think of ways past those challenges as well. And I think the first point to make is the concept of the idea of self-determination. If you look at the idea of self-determination, uh, going back to Lenin, going back to the advocacy of self-determination, it's there. It's a part of the Soviet constitution, part of the Soviet imagination, the idea of self-determination. And the Soviet imagination of self-determination finds its place. Again, the advocacy of the Soviet Union, that finds its place in the International Covenant on Civil and Political Rights, International Covenant on Social, Economic, and Cultural Rights. The first Article 1 talks about the principle of self-determination, right? And look at the Indian Constitution. That is a principle which is not there. And you can argue that the Indian Constitution, far from being encoding the principle, will actually it puts in place a strong center and weak states, right? It might be the exact, very, very, very far from that particular concept. And here, what do you do in a context such as that? Here again, my reference point is Balgopal, who made the point. He says, see, you go to Kashmir or you go to the Northeast, right? People will begin any discussion or talk by referencing International Common Social Economic, ICCPR, ICESCR. Throughout India, people will begin by referencing the Indian Constitution. So it tells you about a different relationship people have to the document itself, and the fact that how people take forward, how you take forward advocacy of certain rights, what the limitations of certain frameworks might be. And that's a point I think we need to acknowledge and understand and think of ways forward, keeping these limitations uh, in mind. And that's, I think, that's fundamental. And maybe one more point on this is uh, even if you look at the principle of federalism and the asymmetric federalism, and the recent judgments of the Supreme Court with respect to the Kashmir is a deeply disappointing judgment, because what it does, and it's unprecedented, right? You're talking about the 370 is one point. 370 is one point. But the bigger, I think the more important point actually is what you've done is you've demoted a state in the Indian Union to a union territory. Right? And that has gone unchallenged by the Supreme Court. Do you have the powers to demote a state to a union territory? Do you have the powers in the sense to take away the right of people to self-determine, right? Within certain limitations, their own destiny, uh, and convert it into a centralized state. And we've seen that again in the protests in Ladakh in particular, where we've seen the strong articulation of what this has meant. How, for example, when the people's voice completely disappears, right? And the kinds of abuses which can happen, we see in the Ladakh context. And again, the very, very powerful, very, very important protests, which our colleagues and friends in Ladakh have been doing, advocating again for the for a form of greater control over the right to determine, over greater control over their own resources, and determine policy which controls the way the 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 way resources are distributed, the way resources are controlled within Ladakh. So I guess union territory is as far as it gets from the concept of of federalism, from the point of view from the concept of federalism. So that's the first kind of limitation we got to keep in mind. The second, I think, very very important one. In all this talk, if you notice, the one point I did not address, right? Obviously, in terms of the entire question of the uh, economic structure as limiting your notion of freedom, even with the constitution in place, right? And here you go back to the drafting of the Indian Constitution, go back to the concluding speech by Ambedkar in the Constituent Assembly. He makes a very, very important speech, very seminal speech, where he says, from 26 Jan 1950, we're entering into life with contradictions. On one hand, we have one man, one vote. On the other hand, we have we have inequality when it comes to the social and the economic sphere. And he says, if we do not address the level of inequality, the structure will blow itself up. And so there's a way in which there's almost a prescient understanding, saying that this is not sustainable. This kind of economic inequality which we have in 1950 is not sustainable, and we have to address it. And from this point, you just connect it up and you link it up, right? I want to make a connecting link to the contemporary 2023, 2024, right? There's a very important paper which by Thomas Piketty, who's of course a very well-known economist, and the paper is called, it's very easily available online. It's called "Income and Wealth Inequality in India: The Rise of the Billionaire Raj," right? And the point he makes on the question of inequality, he says between 1961 and 2023, the top 1% of the wealth share increased threefold, from 13% to 39%. Again, the figures are quite shocking, right? 1% of the population of this country has 39% of the wealth of this country. And the bottom 50% of this country has 6 to 7% of the wealth. And the other, I think, very shocking figure to me is the idea that this what Piketty calls the billionaire Raj, headed by India's modern bourgeoisie, is now more unequal than the British Raj headed by the colonialist forces. And so there's a level of inequality which is absolutely kind of, in Ambedkar's present words, it's not going to last. But you can't have this levels of inequality. And go back again to Piketty's other work, which is again a very, very important book called Capital and Ideology, and where he makes this point. He says that the time period post the French Revolution up to World War One and World War Two were the most unequal time, uh, unequal the world had ever been since the time records began of mapping incomes. And he says what happened post that, right? This levels of high levels of inequality were unsustainable, and obviously the world ended up with the rise of Hitler, World War One, and then World War Two. So the levels of high levels of inequality are unsustainable. Is a broad point. The connecting link he's making, he's saying the levels of inequality we saw just after the French Revolution leading up to World War One and World War Two, the same levels of inequality we're seeing in the world today. So again, that might give us some kind of a clue, right? To say that if you're looking at the rise of the right from France to the US to India to many, many countries around the world, that give you a sense that there might be something larger underlying it, and there's something larger which we need to understand a little more closely of the question of, of inequality itself. Okay, how do you address this question of inequality? Piketty has a range of proposals. Again, I'll just put it out there and say that, what is possible within the framework of the Indian Constitution is an open question. But I think this still, I'll go back to Balgopal's point that we say there's four corners of the law. Still, a lot is possible within those four corners, right? And what he's putting forward as a proposal is what he calls a case for what he calls a participatory socialism. And broadly, the point he stresses on very, very, very strongly is what he calls the idea of fiscal justice, right? Again, preamble of justice, social, economic, and political. What do you mean by fiscal justice? Again, if your point is the point of where the world is going and the way India is going definitely is income inequality or wealth inequality, you address that. You can address that through without trusting the tax regime. And again, the point he goes back to is the most equal, right? The world has ever been is between 1950 to 1980 with a tax regime with a proportional tax regime which tax people more heavily at the higher end of the tax bracket, and that's what has changed dramatically. Where there's no tax on wealth, no tax on inheritance, uh, and proportionate income tax again is in some parts of the world out. Again, this is an interesting point to note that the country which does, we still have, of course, a proportional tax regime. What is a flat tax regime? Is the country which has a flat tax regime Russia, right? Russia moved from being one of the most equal countries in the world in Piketty's analysis to being today one of the most unequal countries in the world. And that again, he makes the connecting link to the tax regime, right? So fiscal justice is clearly one part of the solution one needs to move towards. And of course, the other parts of it, I think we're reasonably familiar with, which is, of course, a greater investment in the question of health, education, and the social sector, can be done within the framework or the framework of the Indian Constitution. Again, where the links up to as far as the Constitution is concerned is if you're saying, does the Constitution at all reference the question of inequality or is completely silent at the point? You'll go to articles, the Director Principle of State Policy, 39 BNC, we talk about the concentration of wealth in a few hands and the fact that the state is mandated, state is directed to address the question of the concentration of wealth in fewer and fewer hands, right? So there is a principle of the diagram principles which references addressing the question of inequality. Okay, the last point I want to get to, maybe the most difficult point, and I don't really have any strong answers, but I'll make the point anyway, is fine, all this is still, I'll say all of this is within limits, possible within the framework of the Constitution. But this is the question I don't have an answer to. But if you're saying, right, if you're saying what you're facing is a fascist onslaught, in which part of the world has a fascist onslaught been responded to by a framework of the Constitution? In every part of the world where fascism has come in conflict with the constitutional framework, be it Weimar Germany or be it Italy, constitution has been thrown aside ruthlessly. Before you know it, it's out of the picture, right? And before you know it, a fascist order is in place. And what is a fascist order? Again, going back to some thinking on that point, very interestingly, again, even Hitler, right? Hitler, the point he makes is uh, political power established the popularity and stabilized the force. However, cannot endure until supported by social tradition, which is the final cornerstone of power. Popular authority stabilized by force and aligned with popular traditions may be regarded unshakable. So the idea that, at the end of the day, when you talk about fascism, it's something which has a deep popular context to it. Again, this is the point made by, I think, a very, very important book by Jairus Banerjee on fascism, looking at essays, looking at fascism in Europe. And he quotes Clara Zetkin for the proposition that you should see fascism as a mass movement. There's no way out of thinking of it in that particular sense. And you can't think of it as a military terroristic movement, but as a mass movement with deep social goals, right? And so that's the challenge in the sense that you're confronting, right? And in India, we see that, of course, the idea that other deep social roots to this ideology. If that is so, what then can you do, right? And here, maybe I'll just put forward a proposal. We can think a little bit about it. Is that what I think the current range of protests using the language of the Constitution have shown is that there is a possibility of thinking of the values underlying the Constitution so, as being a base to really build on. And going back to the values of, what do you want end of the day to protect is the questions of dignity, the questions of equality, the questions of, of fraternity are the central values which we want to take forward, even in a combating or fighting of a fascist force or challenging, in a sense, the deep social roots. You're challenging the deep social roots by saying that, one root is a constitutional rooting of these ideas. But I get the point that constitutional rooting can only go so far, and where else will you root to find these values, as it were? And then I think there's a question of going back, in a sense. I mean, going back to the question of tradition and culture, and seeing what are the ideas. How do you go back to traditional culture and think of what are the ideas within traditional culture which put forward a more emancipative liberatory, which have more emancipative liberatory potential. And I think each state, I'm sure, has its own stories, own narratives to build on in that particular context. And in Karnataka, of course, we have the entire Basavana tradition, which which is the Bhakti movement and the idea that the ideas put forward with Basavana at that moment in time, which challenge both the idea of which put forward both the notion of equality and challenge as well, of course, the idea of class superiority. And that's again a very important tradition to go back to. I'll end by just referencing one poem by Baswana which communicates some part of what might be there in traditions and cultures in trying to challenge the deep, so-called deep social roots, right, of a fascist kind of a monopoly power. And that is the most famous poem in at least every school child in Karnataka knows this because it's a part of your school syllabus. It's a part again of it's sung quite a bit, so a lot of people know it. Again, it's interesting. I mean, I think you all know this as well as any of us, which is the idea that poetry is not the same in India or India as in other parts of the world. In you go to Europe, people are not singing Shakespeare. People don't might not know Shakespeare in that deep sense. But in the Indian context, uh, poetry is something. It's a part of lived reality as well. And people, it's a part of people's everyday. It's around people everywhere. And here, just there's one poem which in Kannada goes something like "Ullavanu Shivalaya Madavanu, the rich will build temples for you. What shall I, a poor man, do? And a poor man do. My legs are pillars, my body a shrine, the head a golden cupola. For listen, O Lord of the meeting rivers, think standing shall fall, but the moving ever shall stay. Right? Again, I think it's a very powerful account, a powerful response. But actually, one thing which I thought of, which is the Prime Minister speech during the making of the inauguration of the temple, when we saw these images, right, of him leading Lord Ram by the hand and saying that all these years he lived under this awful under a tent. Now we build this magnificent temple for you. Come, live in my temple. And of course, he's a big man leading the little child into the temple. But then you think of it from a Basavanna philosophy context. It's absolutely it's absolutely repugnant to everything Basavanna believed in. Because the idea that your body is a shrine. You don't need a temple to worship. That's the starting point of this particular philosophical understanding. And the fact that the rich and the poor equally can contribute, right? It's not the rich alone. And once you start going on a temple route, and temples is centers of wealth, there's something deeply problematic about that entire line or that way of thinking. Just one example, but I think there are a range of other examples we can think of within culture and tradition to think how we can mobilize that language in defense of what we call constitutional values. So I think the way is really, in a sense, you're challenging the deep social roots of these ideas of the part of the Hindu right through referencing culture, tradition, religion, as well as, of course, constitutional values. Try and see how we can challenge these frameworks and move forward uh, in the admittedly very difficult scenario we find ourselves in. Yeah, okay, that'll be. Thanks, Vinitya.